Time being 9 a.m. I call this meeting to order. Please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay. Need a motion to approve the agenda. Are there any comments, changes?
Make a motion to approve the agenda.
Dana, motion by Dana.
Second.
Second by Justin. Any discussion? All those in favor say aye.
Aye.
Opposed, nay. Motion is carried. The agenda is approved. Need a motion to approve the minutes.
Correction on the minutes. There was, in the minutes, we talked about Subdivision 3, Industrial Minerals, Metals, and Fluids. The minutes don't accurately reflect the motion that was made. That needs to be changed to correct that. So I would move that minutes be approved with the correction, and I believe the commissioners have the correction in front of them.
Yeah, it's been handed to us.
With the correction being made, and just make sure that the ordinance reflects that correction as well.
Motion by Justin. Is there a second?
I'll second.
Second by Dana. Is there any further discussion? All of those in favor of the correction signify by saying aye.
Aye.
Opposed, nay. Motion is carried. The
Do you want to do
minutes
the
are approved.
from Tuesday also while we're at, or Wednesday too?
Certainly.
Oh, I apologize. I thought that was the minutes from Wednesday.
Oh, okay, yeah.
My
Okay.
motion was from the minutes of Wednesday.
Okay, so let's go back to the minutes from Tuesday. I'm
Okay.
sorry.
I'll make a motion to approve the minutes from Tuesday.
Motion by Teresa.
Second.
Second by Justin. Any discussion? All of those in favor say aye.
Aye.
And opposed, nay. Motion is carried. Minutes are approved. Okay, a moment for public comment. Before we do that, I see that we have a rule here restricting. Rule number 10 was brought to my attention. This section of the agenda may not be used as a forum to continue discussion on an agenda item which has already been held as a public hearing. I know that we had quite a crowd at our public hearing, and there was a large number of people that were in the hallway were unable to speak. What is the board's feeling on this? Do we allow some discussion on, and I know there are people here that would like to comment on our ordinance
That had not talked.
that we're not able to speak, simply because we have a full house.
So you're saying let those speak that did not yet get a chance to
If
speak?
the subject comes up, do we allow it? What's the preference of the
I
board?
think people who haven't spoke should have a chance to speak.
Do you have a list of who has? and
No,
who
I
has
do
not?
not. No, it's our public comment period, 15 minutes worth, 2 minutes apiece. How many here would like to speak to the,
That didn't speak.
yeah, we'll never get you all in, but is there a motion from the board whether we allow discussion on the ordinance?
I think that we should allow not discussion, but public comment from the people who didn't get a chance because of the numbers here.
Is that a motion?
Yes.
Motion by Judy,
I'll second it.
second by Teresa. Any discussion? All those in favor say aye.
Aye.
Opposed, nay.
Negative.
1 nay, just Dana. Motion is carried. Okay. Would anyone like to address the board at this time?
Mr. Chairman,
Ken, you already spoke.
I'm not speaking on the topic of the public hearing.
Okay.
Go ahead.
Okay, Ken Jumper, La Crescent Township. I simply wanted to thank you for conducting a very fair and impartial public hearing. And I find it really disturbing that you would continue the public hearing today. There's lots of people who stood in that hallway and left that I know who would have loved to come today and commented, but who didn't know you were going to continue the public hearing. So I find that really objectionable, Commissioner. But again, I do want to thank you for holding a very good public hearing. I think the silent majority of this county who couldn't attend were really represented by the forceful presentation of people who want a ban for frac sand mining, and I hope you'll keep that in mind. Thank you.
Eric Johnson, Houston Township. I've been involved in this debate on sand mining from the beginning, 3 long years. My position has always been preserving individual property rights. And you as county commissioners took an oath, and I quote, "I do solemnly swear that I will support the Constitution of the United States, the Constitution of the State of Minnesota, and that I will faithfully and impartially discharge the duties of the office of County Commissioner to the best of my knowledge and ability. So help me God." End quote. As landowners, our property rights are protected under the Constitution, and this latest proposed ordinance takes away our mineral rights without just compensation. With me today is my neighbor, Leonard Tossison. He has lived on his farm in Houston Township for most of his life. He has been a hard-working, decent, and good neighbor and farmer. His land is all he has. As most farmers will attest to, all the money we make off the farm, we put back into it. And if we're lucky, we can squeak out a living wage and pay our taxes. And Leonard is no different than anybody else. As you can see, he has suffered from serious health issues. He would like to sell some sand off his land that he has worked all his life to own. But some of you say, no, you cannot do that because of politics. Really? He could use that income to make life easier for himself and his family. Medicare does not pay for everything. How can you deny his property right to make income off his land that he owns just because of what the end use of that sand is?
Larry Letterberg, Mount Prairie Township. I've lived in this county all my life, and I've never seen anything like this as far as the taking of property rights. It's been bad over the years. When I was a kid, people could do pretty much what they wanted, and that wasn't always the right thing. But this is like stealing our mineral rights, which we paid for when we bought our property. It's the same thing as if I walked out here in the street, somebody picked my pocket. I feel like I'm having my pocket picked right here by our own commissioners. And I think this could be a great opportunity if we had a little more time to come up with some things. One of the main problems here is that producers have a boom and bust economy themselves. And at times when it's bust is when a lot of the producers need to use their resources. If we had a more stable farm economy, I think with the opportunity to come up with good ideas by some of our entrepreneurs, people who think, they used to do that here. It wasn't all regulations. Sometimes incentives are the answer. And I think with all of us together, working together, we could come up with a much better farm-based economy, especially here in southeast Minnesota. A lot of that being based on organic farming. Now, these are my opinions. Without a lot of chemicals, without GMO crops, solves a lot of problems. I think somehow we should work toward that and toward putting more money into our producers' pockets instead of having to rely on our resources at certain times when it's needed. Thanks.
Commissioners, I'm Betsy Reedy, Money Creek. And as Commissioner Walter and Commissioner Zemieski know, I was present at almost all of the study group meetings, week after week, month after month. And I'm a little concerned because some of the language in the non-conforming mine section of the proposed ordinance, it seems to me does not reflect the concerns that, major concerns that I heard in that study group. One, you guys spent a lot of time talking about setbacks, and the grandfathered mines in this ordinance will be exempt from any setbacks, and that's very troubling. And the other thing that you talked a lot about was getting a handle on the grandfathered mines. And Dan Griffin, in particular, came back to that issue again and again and again. We got to get these mines in hand so we know what's going on in the county. And it seems to me that neither of those issues, in fact, both are kind of destroyed in this proposed ordinance. And I think that language should be changed to reflect the concerns of the study group. And it would be, I've got it right here for a minute. non-conforming mines would be on page 3 of the draft that I have. And it says that the original text says all legal non-conforming mining and extraction operations shall comply with all setback performance and land reclamation density, volume, size, and land reclamation standards that's set forth in sections blah, blah, blah. And that wording is repeated a couple of sentences later. It seems to me that that original wording was the intention of the study group. So I hope you guys will go back to that. Thank you.
Okay, thank you.
Hello, Commissioners. Brian Lavelle, Black Hammer Township. I was here last week, but I feel impelled that I need to try to clarify and bring a little focus into the justification that these property rights people use for destroying the life-sustaining capacity of our county. And I want to bring to the forefront an aphorism that was credited to Will Rogers. And it goes kind of like this: your rights to swing your arms ends at my nose. If you hit me, it's assault. You can swing your arms all you want. And I think most people generally agree with that concept, that we have rights. We all have rights. I have property. Doesn't mean that I think that I'm justified in holding the county hostage to my stand. And the state of Minnesota was down here with 3 or 4 geologist type state people that were at the La Crescent High School a few years back in the springtime. I don't know if any of you were there, but they used terms like overburden to describe what lays on top of the sand. That's not overburden. That's our drainage. Water is a very scarce commodity these days. How many of you are aware that in Sao Paulo, Brazil, today is the end of Carnival, and there were some rains during Carnival that boosted, they're in severe drought, that boosted their reservoirs, but only to 8% of their capacity. Had those rains not fallen, they were going to only supply water 2 out of 7 days for a city of 220 million, the second biggest city in the Western Hemisphere. That's how precious water is. And it's time that we all realize the value of water. And it's a hell of a lot more valuable than sand to keep us warm for a couple more years.
Mm-hmm. Yeah, thank you.
Thank you.
One more.
Chairs behind.
You already spoke.
Brian Van Gorp. Yesterday I received an article from a friend of mine who's involved in agriculture as well, and it said that last year over 1 million acres of farmland disappeared in the United States to urban sprawl and other things. And I don't know how many acres of farmland were destroyed in Wisconsin due to mining, but certainly tens of thousands. We have a growing population and a decreasing supply of farmland. Now, that should create a problem in your thinking about this issue. The other thing I would say is that the interpretation of property rights is extremely narrow and self-serving here. If someone opens a mine next to my land, I lose half my property value. What about my property right to maintain my property value? Also, to think that you can destroy the land for your own gain in one generation, this land will be here long after everyone in this room is dead. And our children's children will be dependent upon the fertility and productivity of that land. And no one in this room has the right to claim that they have the property right to destroy that land for their personal gain. That is the most arrogant and hubris statement I can't believe it. Thank you.
Steve, 9:15, do you want to?
Just one last speaker. Charlie, you'll be the last speaker.
I didn't get to speak last time.
I know, but we only allow 15 minutes.
But these people did speak last time.
He spoke last time.
Enough.
Because he's a Weezer, he gets to speak twice, is that the deal?
Let the one
Easy.
Just let him speak. This is the last one.
Okay,
Steve, let's discuss.
this is, I'm Charlie Weezer from La Crescent Township. I appreciate it if I would be interrupted. Thank you.
Should be.
After you receive the findings from our county attorney for the new proposed mineral extraction ordinance, I would like to have you, the county board, ask Mr. Yant one question. So we know the county board is representing all the citizens of Houston County. The question is, would Houston County prevail if this ordinance is challenged in a court of law? If he says it is questionable, then I will have to ask you, the county board, why would you jeopardize the tax money received from the majority of the citizens of Houston County on a lawsuit that you could not defend? Thank you.
Insurance pays for it.
Easy.
This has been the
I
most
would
disgusting
like to
public comment
request
period
the
you've ever had.
opportunity to speak. One person who did not speak.
Make it short, and that's that. That's it.
Okay.
No, Jeremy, take your seat.
Jeremy,
take a seat.
Yep.
Name?
This conversation
Your name,
was
please.
held-
Introduce yourself, please.
I'm sorry. My name is Lorraine Culver. I am from the city of Houston. I am not a property owner. Oh, he says. You know, we do speak as if property rights are the primary, basic, most important right. Absolute. But there are rights to the commons, air, water, what you can look at, what you can hear. These rights go back to the time of the Magna Carta and even to the Roman Empire. These are not new rights brought up by environmentalists. Those need to be respected too. Property rights are not the only and most basic rights.
Thank you. Okay, first on the agenda, Carol Lapham, letter of understanding.
Are there no seats empty for you behind the rail, Ken? Because generally, we don't have people in
Sharp
front.
told me to put a chair up here, so I said here. If you want, I'll move. I mean, you manipulate everything else today. That
Works
was the
for
most
me.
disgusting public comment period I've ever seen.
You know, one more outburst and you can be asked to leave.
Thanks, Carol. Come on up.
And actually, I'm assuming you all got a copy of the letter. This is just our annual letter of understanding with the State Auditor's Office regarding our 2014 audit, and it outlines the services that they will provide and the information that we will have to provide to them in order for them to state their opinion regarding our financial statements.
It's basically their engagement letter, I guess you'd
Engagement
call it.
letter, yes. Mhm. And they have started the audit already. It sounds like there were some people on leave that this just didn't get sent out until now.
So you need a motion to approve it?
Yep.
I'll make that motion.
Motion by Judy to approve. Is there a second?
I'll second it.
Second by Teresa. Any discussion? All those in favor say aye.
Aye.
Opposed, nay. The motion is carried.
And I gave them 2
Yep.
copies for you to
Thank you,
sign.
Carol.
I'll get those later.
Yep.
Thank you.
Okay. Linda Barr. There we go.
Morning.
I'm not sure what the agenda says. I didn't get to look at it, but I am here this morning because I need approval from you to accept adult mental health grant funds. And this year they're actually having the county board sign an acceptance. So I'm going to kind of try and summarize what exactly you're accepting. The adult mental health grant funds, we receive, some are federal, they're particularly talking about state mental health funds here. They would include the Adult Mental Health Initiative, which we call CREST, and those funds are spent a certain way. We have regional crisis funds. Those are spent a certain way just for regional crisis. We have housing with supports, possibly. We have projects for assistance of homelessness, even in our small county. And then there's also community support grant services. All of these actually, in accepting these adult mental health grants, we have to make sure we follow the fiscal rules, and some of those include, I'm not going to list all of them, but we have to make sure the expenditures, of course, qualify and they are allowable. The other things, we have to make sure they're all for services. We cannot spend any of the adult mental health funds on capital expenditures, and they define capital expenditures as land, buildings, equipment, even like software that would be considered, or anything in excess of $10,000 that would fall under the category of capital expenditures. Mostly, they get into all kinds of laws and on the contract, and you might want to sit and read through it a little better, but this is really no different than anything we've done in the past, and that's why we have to make sure our money is spent correctly and in the right fashion. And basically, I believe I probably need a motion and a second to approve accepting adult mental health grants for Houston County.
Is anything changing from last year to this year in how we can use the funds, that they've changed how we have to sign for it?
No, not overly, other than I do know by 2016 the CREST funding, the fiscal host, and it will be changing for all of that. So we are in a transition year, but this is just for the calendar year 2015.
Okay.
So it's really very similar, not a whole lot of new, probably that we get a little less. The one grant they list in particular on the back of the contract is the CSP grant. That's called Community Support Program, and there are restrictions that fall under that grant, so we have to be very careful how we spend that.
Okay.
But we already are, so we're in good shape. We know what we're
Good to
doing.
hear.
Then I'll make the motion to approve.
Motion by Judy to approve. Is there a second?
Second.
Second by Justin. Any discussion? All of those in favor say aye.
Aye.
And opposed, nay. The motion is carried.
Thank you.
Linda, could I ask you something?
Sure.
How much do these grants total?
Oh, boy. That all depends. It depends issue. I can tell you the CSP grant right now is $77,507. Our CREST grant was supposed to be, like $88,000 some odd dollars. That is getting revisited right now, and I am in belief that that probably will increase a little bit. In past years, that's been like $130,000. We took a real cut this year. Now I'm thinking, though, I'm hoping we'll end up with $112,000. The next directors meeting, we will be reviewing all of that. And the directors actually are the ones who create the amount of the allocation each county gets. So I think right now there's 5 out of 10 directors who want to review it and changed. So that's good for us, and we surely can use the money. So, that help? Yeah.
Did I call for a vote? Is there any further discussion? All of those in favor say aye.
Aye.
Opposed, nay. The motion is carried.
And then you can just sign those when you get a chance. You don't have to.
Like
You
that.
guys can keep them.
Okay.
Okay. And Tess, we have some personnel discussion. Tess Kruger? Yeah, I saw her back in the doorway.
Sure was.
Good morning, Commissioners.
Good morning.
Good morning.
Just have a brief HR agenda this morning. Oh, that's fine. At this point, we have two matters on the agenda for the jail, and that is the transferring or reappointing, if you will, of Matt Mackey, who's currently a full-time lead. He has made a request to go back to full-time regular status dispatcher. It's with the recommendation of both the jail administrator and the chief deputy that we grant his request. He would then be reappointed as regular status. It does not require probation. He's already served probationary status for this position as a former position of his. B23 step forward an hourly wage of $22.32 per hour effective March 8th. There is the language down below on the action requested reflects all those elements.
Motion to approve.
Motion by Judy,
I'll second it.
second by Teresa. Is there any further discussion? All those in favor say aye.
Aye.
And opposed, nay. The motion is carried.
And did you gentlemen have a comment on that particular one? Well, and knowing that we had this request on the table, we did an internal search for a replacement for a lead jailer. Chief Deputy Lapham and Jail Administrator Schultz and I interviewed 3 applicants. They were all this was an internal posting. They all had very sound qualifications. However, one did stand, I would say, heads and shoulders above the other 2 in his education as well as his experience. So we are here to recommend Mr. Jordan Rooker as a full-time probationary status for this position. Lead jailer dispatcher, that's a B32-2 at the hourly rate set forth at $26.21 per their collective bargaining agreement. Mr. Rooker came to us not that long ago. He became a jailer for Houston County in last August. However, he has approximately 4 years of jailing experience, and he also holds a Bachelor of Arts in Criminal Justice. And so, would you like to comment?
Even when Jordan came on board with us back in August, his training went very well. He caught on so quickly. We put him in the dispatch room. He caught on again so quickly in the dispatch, which he never dispatched before. So it's reflection on him on how well he quickly regains his training, and he does perform very well in the jail. And I do highly recommend that we put Jordan on as the lead position.
Chief?
All 3 applicants were very qualified, but Jordan did stand out. He shined, so we're looking forward to having him.
I think that it's good that we note that all 3 candidates were very qualified.
They were.
I mean, that
Absolutely.
says a lot for our staff over there, that 3 can rise above to the top, so we're
I would have been
very
fine
fortunate.
with any one of the 3
Yep.
on board. It's just that we have to go by the scoring and how we receive the information from them and their education.
And we
It is a competitive process, so.
Mhm.
We
Right.
appreciate their willingness to take that next step in their career. You know, even
Right.
the 2 that didn't get it, they're willing to take on that responsibility and role as a lead, and I respect that. So,
So, we're looking for a motion this morning to appoint Jordan Rooker as a full-time probationary status lead jailer, effective March 8th.
I'll make that motion.
Motion by Judy,
I'll second.
second by Dana. Is there any further discussion? All of those in favor signify by saying aye.
Aye.
Those opposed say nay. That motion is carried.
Thank you.
thank you.
Does the commissioners have any other questions for me at this time?
Don't think so.
Any questions? Looks like you're free to go.
Thanks a lot.
Thank you. Thank you. Okay, consent agenda. We have an invitation for the annual meeting of the Houston County Township Officers Association on April 9. It's at Good Times. It is basically unhosted, so you're on, pay for your own.
RSVP.
Pardon me, no
No,
RSVPs,
it's just
no.
a meeting.
No. There is no meal, and refreshments are on your own. And we need a motion to accept that.
So moved.
by Justin. Second?
I'll second it.
Second by Teresa. Any other discussion? All those in favor say aye.
Aye.
Opposed, nay. The motion is carried. Unfinished business. Roxanne.
The only thing that I've got is the one thing that was brought to my attention that I know the study committee had talked about rewriting this. It found its way back in there. I thought this should probably be brought up under the in the non-conforming mines. Originally, we had talked about. I know Teresa was there too about bringing the mines into compliance. The one sentence just says all non-conforming mines and extraction operations shall comply with, and it lists only 4 things that they have to comply with. And I know the study committee had mentioned that that should be taken out, and the word all standards should be put in there just to help bring them into compliance.
What page?
3. And so I guess I would just like to see that put back that way, that it brings them all into compliance, and just using the word all standards.
Instead of only.
Correct.
Yep.
Yep.
Whereabouts is that?
Right here, Steve.
On there, okay.
Yeah, you see it right halfway.
All legal.
Non-conforming mines and
Yeah.
extraction operations shall comply with.
All standards as set forth in this section versus just only 4 things.
Was this in the original?
It's been bounced around and taken in and taken out.
Yeah.
And that's why.
Have you discussed it with planning and zoning?
Well, that
as
was
to-
part of it when we had a discussion in the study committee, and this is the one that the planning and zoning had that they brought forward. So I'm sure it got put in at that point. But just to make sure that the intent of what the study committee's intentions were to bring that into compliance, that would have to be changed. Otherwise, you're not bringing them into compliance. You only have to adhere by 4 rules.
Okay, so you want to take out with the only?
Yeah, see where it says
Take out
all
only.
legal non-conforming mines and extractions shall comply with only?
Yep, take
And it
that
has
out,
just
put
4
all.
things? Yeah, it should be all standards, because otherwise,
Do you want to take out density, volume, size, and reclamation?
well, you would, because then that would incorporate the word all, you know, it would include those, so it's kind of redundant to say all
Teresa,
and
how
not
did
say
that
those.
come through the study group?
I thought
You
we had
remember that,
decided
Teresa?
not to put in all. We wanted just to make sure that they conform to the density, volume, size, and land reclamation.
Right, but then you kind of contradict yourself, because I know we've talked many times, I know you've pushed really hard that you want the mines to come into compliance, but if you only have 4, you're not pushing to have them to come into compliance, you're only pushing to have them come into compliance.
Which other,
And those 4
which other
issues.
standard are you?
But like setbacks aren't mentioned, you know, obviously they need to adhere by like setbacks and stuff, that's not mentioned. You know,
Dewatering.
blasting isn't mentioned, you know, obviously, we want to make sure that they're adhere to those
Have
standards
no
as
way
well.
you
so-
wouldn't have blasting in it.
Right, right. So in order to make sure that they're coming into compliance, you'd have to use the word all, because right there, it excludes quite a few things.
I'd like time to study that.
Yeah, same here. I have questions. I guess I'd like to pose to planning and zoning office.
All right, well, I make a motion that, or I'll move that we use the word all in their standards set forth in this section.
Motion by Justin to amend 10110-2705, changing the word only to all. Is there a second?
I will second it.
Second by Dana. Is there any further discussion?
I think we need to check exactly why we put in only before we move on that. But you can call for the vote.
All of those in favor, say aye.
Aye.
Opposed, nay.
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 Second of all, down a few more paragraphs down, it's the last sentence. It starts, any existing legal non-conforming mining extraction operations is determined by the zoning department to pose an environmental hazard or negative impact on health, safety, welfare of residents of Houston County. Right after that, for legal purposes, it probably should say and or county board, since further on down it says, if they fail to comply with these standards set forth in this chapter shall lose non-conforming status. Only the board can really revoke that. We'd have to have, you know, the zoning department to poise an environmental health. It should be the county board too, because if it's going to go that point, the board's already aware of it, and they're the ones that are the decision makers. So that wording should be changed to and/or county board. Does that make sense? You see where that is?
Oh, that's
So, right here, zoning department. So it's just saying that the board doesn't have to have any action to revoke, but only the board has the option or the authority to revoke. So it should say the zoning department and/or the county board to pose an environmental hazard. Kind of makes sense.
Except the county board could override the zoning department if the zoning department
That's right, but see,
found that they didn't want to.
that's right, but according to this, the county board can't, because it just says is determined by the zoning department only. That's why if you have and/or the county board, then you're right, the county board could override. But as of right now, it's just giving only the zoning department the authority to do so. And the zoning department wouldn't have the ultimate authority to revoke, and that would have to come from the county board. So it kind of contradicts itself that they have the authority to revoke it. So it's just more or less clearing it up.
Is it everything from the planning and zoning?
Yeah, everything
Everything
comes
from
to
the
us
planning
anyway.
Yeah.
Right, but right here it's saying it doesn't have to. It just says operations
just
is determined by the zoning department, not the planning commission, not just if the zoning department sees that it's an environmental hazard, they can pull your permit like that. Obviously, it would have to come to the county board, so it should say that it has to come to the county board. Otherwise, you're giving all the authority to just one individual to determine, yep, there's environmental, I'm pulling it. Well, what if there's not, or what if there's, the ultimate decision should come, obviously, from the board if
Well,
it's
the
going to get to that
ultimate
point.
decision would come from the board, but if there was something that was being violated, isn't that the zoning department's job?
Yeah, I
Is to
think
bring it
we're
to
trying to
the board?
micromanage.
To bring it to the board.
To
You're
bring it to
absolutely
the
right.
board.
To bring it to the board, and that's what I'm saying. Right here, it doesn't say they have to bring it to the board for revocation. It says,
It's just
as
a
deemed
word.
by the department, as set forth in this chapter, shall lose its nonconforming status. That's what I'm saying. It's giving all the power whether to revoke a permit just to the zoning office, which you don't have. So
But by saying and/or, they could if it was a detrimental situation.
Yeah, then it becomes
So
ambiguous.
Then they need to do it even before we meet.
but the board would always have to meet.
No, that's not what I'm saying. If there was, like if something was going on and they went out to a site
Mhm.
and they weren't conforming,
Mhm.
they should be able to put a stop to it.
Right, they
Right
can
there
put a stop
without
to it.
us.
Sure, they can put a stop to it, but here it's saying shall lose non-conforming status, which means they're pulling their permit. So do you want to give the power that they can just, somebody could come in and say, hey, I think that's environmental risk, guess what, you're pulled, sorry, and it doesn't come before the board? Because that's what it's saying it doesn't have to come before the board.
And/or.
Yeah. And then that also opens it up too, that if all of a sudden the zoning department says, no, I don't think it is a environmental hazard or negative impact to health, the board, then it gives the authority, it's the zoning department and/or the county board that could do it. Or if somebody brings the complaint to the board and not, it's allowing it to be either
One or the other, in other words?
That's right, that's
Mhm.
right. Yep, it allows both for the possibility, correct.
But does not necessarily mean
It doesn't tie one particular down, right?
one doesn't override another.
Right.
Okay.
So I move to insert and/or county board after zoning department to poise an environmental hazard.
I guess I don't feel comfortable making that decision without knowing the history of why that's in there like it is.
Sam, question for you, clear this up for us. How that is written, do you feel that would be an appropriate insertion of that language?
The answer to that is this type of question, Commissioner, I'd have to have in writing ahead of time.
Sure.
So I could study it, and then at this point, I could give you advice, but it may not be competent advice.
Okay, so do you want me to put it in writing, give it to you, and then we can clarify that next Tuesday and give you some time to look at it?
That would be great.
Excellent idea.
Because my only concern is just from a legal aspect, it's putting it all onto one particular entity to revocate a certificate which may not have the authority to do so. So if that works, I'll put it in writing and get it to you, and then you can maybe email us back and we'll discuss it next Tuesday.
Can we all get a chance to look at it
Yep.
before?
Yeah, I would. I have some initial thoughts, but I just want to make sure that I'm
understanding what, yeah, sure, okay, we can do that.
Are you okay with withdrawing your motion at this time?
Yeah, and since it wasn't seconded, I guess you kind of ignored that anyway. so.
Right, you're right, yeah.
And then just the last thing, just to bring up for discussion here, the very last sentence of that obviously goes with what I was saying before. Failed to comply with all standards set forth in this chapter shall lose its non-conforming status instead of only those four. Inserting the word all in replace of the density, volume, size, and reclamation, and that would be a motion.
I'll second.
We had reasons why we put in those four, but I don't have it, my initial books with me to see our discussion on it, because we did have a reason to list four things.
What were they?
There was
I
the
just
four
didn't
things,
bring
and then we discussed all, and
We
that
never
was where it
did
was.
discuss all, though, that I remember.
Yeah, we did, because that was where we came into, well, do we want to bring the non-conforming into compliance? And to stay true to Section 9 of the ordinances, you kind of have to do that. And in Section 9, the intent of the ordinance is to permit non-conforming uses or structures to continue until they're removed, but not to encourage their survival. Obviously, staying consistent with Section 9 of the ordinances, you'd have to do that, otherwise you're kind of encouraging it. So,
Well, in
that's
some
the
ways,
issue.
you're just asking a redundant question from what you asked before.
That's exactly right. It's just taking out those words and inserting the word all to keep it consistent, that they comply with all standards, not just a select few standards. Otherwise, you're not really bringing into compliance if you're not going to worry about blasting standards or setbacks or anything like that. And technically, I think Sam, too, maybe had some discussion about that before as far as how that's worded. Setbacks really aren't being addressed in here or something. I think we talked about, or you discussed with some people, too. So that would be my
The word is left out.
That's correct.
And then, like I said, you'd have to ask the study committee and the Board of Adjustment, or the Board of the Planning Commission, why it was or was not, and I guess that's a policy decision for the board.
Yeah.
And I would rather research it.
All right, well, motion and second on the table. I'd call for the vote, Mr. Chair.
Motion is made by Justin, seconded by Dana. All of those in favor, say aye.
Aye.
And opposed, nay.
Nay.
Nay. Motion fails.
I just need to research that again.
Just a little more information. I don't want to, I just,
Let me look it up ahead of time.
Yeah, I just was trying to bring it up because I know you'd mentioned you wanted them to stay in the compliance, and that's what that does. So
Oh, I
just to
do.
stay consistent with what you're
Yes.
saying.
Why would you allow them to blast without record?
Other than that,
I just don't have my notes with me while we did put it in.
and I'll get that to you, that in writing if you,
That's
Sam, I
fine.
appreciate that.
Sure, no problem.
All right, and we'll talk about that next week. All right.
does anyone want to discuss the findings prepared by
Haven't had a
county
chance to
attorney?
study them.
Yeah, and I really haven't had a chance to look through them.
Yeah, they came kind of late in.
From what I saw,
I
looks
thought
good. I
they were-
appreciate your work, Sam.
Thanks for your
Thank
work.
you for doing that.
Do you have any comments you want to make on those?
Well, the only thing that I would say is that, the task that was asked me was to draft findings of court of this proposed ordinance as amended on February 18th. And I've done so, and I've provided to you that for your review. And the question is, I think, is that has been asked here explicitly, and I think it's been asked implicitly, is if adopted, will this ordinance be upheld by the court? The board in these type of situation acts as a legislative body, and so you have to have a rational, it's assumed, whether it's our state legislature or you acting in a legislative capacity, that you have to have a rational basis for your actions. When you have sometimes you act in a quasi-judicial role, though, and that is when a situation where something goes to the Board of Adjustment and for some sort of permit or whatever has been denied, and then it comes to you to decide, and that's a higher standard. As opposed, you have to have what that is really is. It's if you want a number, it doesn't really exist in Minnesota law. But the answer to this is to that question is, I can't give you an answer, and the reason is because I'm either a judge, member of the Court of Appeals, or member of the Minnesota Supreme Court, or possibly the U.S. Supreme Court. But what I can tell you is where the law is my review of the law would suggest, and I think that the board has three options before it. One would be to ban. Number two would be to regulate. And number three would be to do nothing. That's always an option. regarding a ban. Given my review of the law, I would believe as a general rule that a zoning ordinance that prohibits a use altogether must be proved to be necessary to protect the health, safety, morals, or welfare of a community. And I believe as well that it would be necessary to be able to demonstrate that silica sand mining regulations could not be adopted that would adequately control the potential harms from the use. A total ban of a use, if it's being considered, it's my understanding and review of the law, it seems that the courts will require a demonstration of a compelling need to enforce the prohibition. And stated another way, when a land use ordinance prohibits a use entirely, it will be scrutinized particularly closely. Again, I believe how you can read that is that prohibit a use entirely, it's a taking, and that you'll be looked at under the standard of a quasi-judicial fact finder. Regarding regulation, I'm unaware of a Minnesota case dealing with validity, explicitly with the validity of a ban of a use in a zoning ordinance. But Minnesota case law does discuss the validity of quantitative limits on land uses. And again, I believe the standard is that you must, the action, if you would go through a regulation type of path of silica sand mining, the regulation and limits must bear a sufficient relationship to the public health, safety, or general welfare of the community. And again, I believe it falls under that rational basis standard. What I know locally is that Fillmore County has dealt with this issue by regulation. Winona County has dealt with it by regulation, and their ban has been challenged. And it's in the area of a conditional use permit, but it was upheld. And the third option is to do nothing, fall back on the old ordinance, and then if someone would want to do silica sand mining or use their land in whatever uses, it would again go through the process where it would go out to the Board of Adjustment if it was denied or granted, and then it would go to the board for the decision. Also, I have looked at this through the lens of those three options as far as the insurance office, or the MCIT, our insurer. If you view a ban as a taking claims are generally not covered by MCIT. Mixed claims, land use appeals coupled with the takings claims are often defended by MCIT. However, while MCIT may also defend the takings portion of the claim, it will likely reserve its rights to exclude payment of damages for anyone whose economic ability was stopped. So if you had a land use, silica sand mining, that was not being able to use for a certain period of time, we could be on the hook for the economic loss. MCIT also generally does not cover lawsuits that are in the nature of an enforcement action, i.e. those initiated by a county to prohibit a certain use of a land. That said, what we do and do not have coverage for will be determined by the person bringing the lawsuit, because it depends what they're suing us on. And what they're suing us on, then we would take that to MCIT, and then they would see if they're going to provide coverage or not, and then we would go from there. So that's that's the answer that I can give you regarding the options that are in front of the board, and as far as enforceability. In that, oftentimes in court, I did it yesterday, that there was some question in front of the court. I thought I made a pretty compelling argument, and I thought I convinced the judge, and then the gentleman on my left-hand side made another, what I thought was not the best argument, and the judge actually chose a middle approach. And so what I think is contained to my opinion, and my opinion where the law would be, but ultimately that is decided by not only locally the one person in the black robe, but later on multiple people. And so I can just give you where I think the law is at this time, what your options are, and then it's up to the board and the commissioners individually to make a decision.
So in short, what you're basically saying is you cannot ban all mining in the county, but you can regulate the mining.
What I said was, I believe, is that I don't know what would happen if a ban was put into place. The courts will decide that. I think it's a taking. The takings are held. It could be potentially a taking depending on the claim that's asserted. And that takings are, my understanding of the law, in review of that, they would be held to a higher standard when you're when you have it blocking an economic use. If it's regulation, there seems to be some case law on that. that the boards would have the ability, or under zoning, to, if you make certain findings and you can show there's a rational basis. Also, that's supported by what has happened in Fillmore County, and again, more importantly, I think in Winona County, where it was a little bit different than what we have here, but it's being proposed here. But it was upheld by the courts, and so exactly what will happen, what is unenforceable and is enforceable, I can just tell you what the standards are and what we'd have to do to argue in court.
And the board does have the authority to enact legislative zoning?
Yes, you do, and there's specific language, and depending on how it would be interpreted by the court, that there is the word prohibit used in there.
Mm-hmm. Yep. So we can regulate certain uses as long as we're not banning the entire industry.
I would say that you have if there's case law, and again the other counties' experiences, that you certainly have the ability to prohibit, and if it's prohibit through, to answer that question, I suppose is that something we're familiar with, whether if it's like a pornography store, a strip club or something like this.
A tire burning plant or something?
Yes, yeah, in something where it can only be in a certain location. You can't serve alcohol, let's say in a strip club or pornography type thing.
Mm-hmm.
Certain location, you could probably put certain clothing that could be worn, alcohol couldn't be served, you can only do it at certain hours. And those regulations does not block somebody from engaging in that economic activity, but what it does is it perhaps makes it economically unfeasible to engage in that. I'm not saying that you couldn't do it, but maybe you did not want to do it. And oftentimes you will see that. I know in the North Dakota experiences that's where my law school was, there were always gas mines and oil mines in western part of the state, but it wasn't economically feasible. And so once it became economically feasible, then he operated. Mm-hmm. And so it's the same thing here, is that certainly I think the case law would support regulation of this, but it has to be, again, you have to have finding, and you'd have to show there's a rational basis for your action. And if it was a ban, certainly the board, if it chose to go that route, I will do my best to support your action. But it is a higher standard. There does not seem to be a lot of case law out there on that. There are some that I've been provided from other states and other jurisdictions. But that, again, whether it would be upheld, enforceable, unenforceable, that's for the courts to decide, frankly. And it depends. What the universe we'd be fighting in would be the contents of the four corners of the document we received in the lawsuit.
Mm-hmm.
Any other questions?
And if nobody files lawsuit, it's a moot point, basically.
And that's an excellent point.
I mean, I just don't want to be basing decisions on speculation. I mean, that's the thing. We get a lot of the fearful, I'm going to sue you, and then you ultimately just back down right away. I just don't want to impose the inevitable that we are now speculating against something taking place that may not take place. I just want to clarify that.
Well, and that is always the case, is that we're in a reaction method, and in this case, is that if you would make an action, mm-hmm. then we would react to that. And so if there is no action, we have nothing to react to.
Mm-hmm. Do you have any findings as far as on the flip side of that in your studies, as far as if your findings do show that there are potential for health and environmental issues and things like that, is there anything in there that discusses, especially like MCIT, as far as covering the county if they knowingly knew about something and didn't take action to protect and preserve or to uphold, Statute 145A? I mean, is there anything in there that we wouldn't be covered if we blatantly didn't protect when we knew there was issues?
Yeah, and I apologize again, but that's the type of question that I hesitate to give you an answer to. Not that I don't want to give you an answer, but at this point here, I'd ask you to kind of frame that, and then I would get the best answer I could to.
Yeah, I'll put that in writing. It's basically the same question that you just answered, just on the flip side. You know,
Okay.
we're protecting the side over here on the industry. I'm just curious if there's anything protecting the people on the other
So-
side.
I think that was
in your findings of fact,
So the question would be.
I did read his article.
Yeah.
It
So the
wasn't-
question would be, is that if we knew there was a tire burning plant, to use your example, and we knew that there were health effects, could we be liable for not enforcing that? I suppose there could be a situation that would occur too. And then as far as what MCIT would do, frankly, again, it's something that, again, it's going to be defined by the four corners of the lawsuit that you'd receive, and then you would send it to them, and they would make their determination.
So basically, the board's in a sticky situation. You're, for lack of better terms, you're damned if you do and damned if you don't, where you could get it on the opposite side as well.
And
But it sounds like we're better off regulating, restricting than we are to totally ban it.
I don't know. I don't know if that's quite what's being
Doesn't
said,
sound
but
like that.
Because occasionally you do see lawsuits when I was in private practice where it's possible to sue an insurance company for failure to provide coverage.
correct.
So you do see that sometimes.
Mm-hmm.
And so, I mean, to answer your question the best I can.
Mm-hmm. Yeah.
Any other questions?
So as long as we allow people to mine, but we can regulate what they're mining.
I did read your findings of facts, and I thought you did a great job.
Well, thank you.
A lot of good. Just learned like a timeline of what we've done.
Well, and then I would tell you too is that is a creation of others' work. That's the two what I call frac sand committees that work, the environmental services, and then the minutes that were very helpful. Being able to go back and reconstruct this.
I thought it was a great thing.
That was you're seeing my name on a lot of other person's work.
Thank you.
Thank you.
Thanks, Sam. Any more questions, discussion?
No, I'll get that to Sam, and then we'll
Sounds good.
discuss it in the next Tuesday. We'll
Excellent, great.
have our
Thank you.
actions.
Highway Department building repair, or building, period. Meeting this afternoon. I think, what is it, 1:30?
This afternoon again?
I thought it was last
We
week.
had it last week.
They have it again.
Well, we're talking with Donna.
Oh, I apologize. I know there's a department head meeting at 1:30.
Yeah, well, it kind of surprised me too, I'm sorry. I talked to Brian this morning.
Okay.
And following the department head meeting, we'll meet with Donna and Carol, I guess, discuss our finances, so to speak, on that.
That's today? you
Yes,
said?
yes.
You have following the department head.
Following department head. I guess you and I didn't write it down, and Brian did.
Well, I remember they talking about it.
Yeah.
I thought it was right after the meeting, not at the department head, but
Okay.
that's fine.
Anything new on the historic jail?
Nothing to report.
I think we were going to wait till that EDA,
Mm-hmm.
see if we have interest at that time.
Okay,
And that's the end of March, I believe.
March 26th.
March 26th.
okay. And Commissioner reports. Judy, would you like to lead the pack?
Sure. I've just been really busy with negotiations. We've been up here an awful lot negotiating,
Yep.
Dana and I, and Tessa and the different unions, and we seem to be making some progress. So,
It's tough, kind of tough going.
yeah, it is. You learn a lot while you're doing it too.
Mm-hmm.
So, it's a learning experience. But that's mostly what I've been up here for.
And Justin, anything new?
Nope.
Okay. Teresa?
I did, after that EMS meeting, remember last week I told you I was contacting our legislatures. I did hear back from Jeremy, and he will support our region to go under rural health of public health department. Greg Davis, I just got a thanks. He didn't say one way or the other.
Sounds
That
like
was
Greg
one
Davis.
word answer, so I probably will try to get hold of him again. And other than that, I got a notice yesterday that there is a meeting March 12th for the county township meeting. That one at 6 o'clock, and I'm sure they're preparing their meeting for the 9th of April, but
Yeah.
I was wondering if somebody else would like to go to that. I went to the last one.
Okay, and I could probably do that.
6 o'clock at Redwood,
At the Redwood, okay. When is that again, March 12th?
March 12th. They
Anything else?
really like it when we come. They really like the communication between the board and the townships. So,
And anything further? Teresa? Dana?
I too was involved in negotiations with Judy, and Judy summed it up pretty good. It seemed to be getting somewhere on some of them.
Mm-hmm. Okay, and I
That's
had
it.
kind of, is that it?
Yeah.
Okay, and I had a pretty quiet week also myself. Okay, has everyone examined the claims, human services, and license center disbursements?
Yeah, we'll just pass them down.
Yes, I have.
Yep.
I'll make a motion to approve the claims.
Motion by Teresa,
I'll second.
second by Dana. Any discussion? All of those in favor say aye.
Aye.
Opposed, nay. The motion is carried. And then we are to consider adoption of a resolution authorizing application for Minnesota Housing and Finance Agency Family Homeless Prevention and Assistance Program.
Is that the one through SEMCAC that we got the letter
Yes,
on?
it is.
Questions, comments?
Who's doing the application? Semcak?
Semcak. I think it's a good program to support.
And we have supported it in the past.
Okay.
So I make a motion that we adopt a resolution authorizing application for Minnesota Housing and Finance Agency Family Housing Prevention and Assistance Program.
Got it. Motion by Judy, is there a second?
I'll second it.
Second by Teresa. Any further discussion? All those in favor say aye.
Aye.
And opposed, nay. That motion carries. Okay, department head meeting at 1, Justin and I. And next department head on March 24. Was there any further business to come before this meeting?
That worked good, you guys can go on to the next. Yeah.
Any further business to come before the meeting?
Motion to adjourn.
Motion by Justin to adjourn. Is there a second?
Second.
Second by Judy. Any further discussion? All those in favor say aye. And opposed, nay. We are adjourned.